private international law in the postgraduate and undergraduate degree programs. He has also acted as a consultant to the Directorate of Legal Education of the Bar Council of India. He acts as an arbitrator at the William C. Wiz International Commercial Arbitration Moot on the international sale of goods at Vienna and at Hong Kong, and also at the India rounds of the Wiz Pre-Moot. Our first speaker for the session today will be Professor Stefan Wagner. He is the director of the Max Planck Institute for European Legal History. He was previously Linklater's Professor of Comparative Law at the University of Oxford and has been awarded the Max Weber Prize of the Bavarian Academy of Sciences and Humanities and the Otto Hahn Medal of the Max Planck Society in 2002, as well as the 2008 prize of the German Legal History Conference. In 2012, a Humboldt Award was conferred upon him in recognition of his lifetime achievements in research. Our second speaker for the session today will be Professor Janice Dencott. She is presently a senior lecturer in Nottingham Law School. She is a senior fellow of the UK Higher Education Academy and was formerly chair of the European IP Teachers Network in 2017 and 2018. She is a long-standing member of the International Association of Teachers and Researchers in Intellectual Property. She is also an author of the Nottingham Intellectual Property Guide for Creatives 2015 and the Intellectual Property Notebook 2016. She also wrote Q&A Intellectual Property Law 2016 and Intellectual Property Finance and Corporate Governance 2018. I would now like to call upon Dr. Risham Garg for moderating this session today. Thank you.
Thank you, Ishita, for the introduction. All right, so we have already agreed upon the sequence of the speakers, and I'm sure this session is going to be very interesting. We have tried to title this session as Interpreting and Applying Transnational Commercial Law. And Professor Wagner has a great and deep interest in transnational commercial law. He is the author of the acclaimed UNIDROIT Principles of International Commercial Contracts, and he's an acclaimed expert on the subject. So without much ado, I would like to invite Professor Wagner to present his views upon the ongoing work and the topic Legal Guides to Uniform Legal Instruments in International Commercial Contracts.
Yes, thank you very much, Dr. Garg. My name is Stefan Vogenauer. I'm calling in from Frankfurt today, where I'm now based after, as was said in the kind introduction, I had been a professor at the University of Oxford for 12 years. The session this afternoon is on the CISG at 40 and the role of UNCITRAL instruments in the progressive development of cross-border legal regimes and trade, and within the conference theme on the interpretation and application of transnational commercial law. I have been asked to speak on a very new instrument. It's so new that it hasn't even been formally published yet. It's what is normally referred to more informally as the Tripartite Legal Guide, and the full title is The Legal Guide to Uniform Legal Instruments in the Area of International Commercial Contracts, with a focus on sales. Now that doesn't trip off your tongue. It's a little bit of a cumbersome title, but it really is what it says on the tin. It's a legal guide. It deals with uniform law instruments in the area of international commercial contracts, and it is specifically focused on sales contracts, which is of course also the main remit of UNCITRAL in the area of international commercial contract law, UNCITRAL being the formulating agency of the CISC. Now, it is informally called the Tripartite Legal Guide because it is, although it's a relatively innocent document, it represents a milestone in the international harmonization of contract law, because it is the first such instrument or text on which the three main formulating agencies in the field, the three main international institutions whose missions it is to harmonize private law, it's the first of these instruments where these three agencies actually did not compete, but collaborated. So it is institutionally a milestone. And these three institutions are UNCITRAL, the United Nations Commission on International Trade Law, UNIDRA, the International Institute for the Unification of Private Law, and the Hague Conference on Private International Law. And the problem that these three institutions are faced with is, in a way, the problem of transnational commercial law in general. And everyone who teaches the subject, as I do, or who studies it, as students do, faces this problem. It's the problem of a multiplicity of legal sources that are somehow interacting with each other, and the status of which is not always clear. Obviously, for those of us working in the field, this is not such a big problem because you just learn your way navigating around these instruments after a while. But if you come to the field as a newcomer, you find it confusing, disorientating. There is a real problem with accessibility and a lack of transparency. And since all these documents, texts, instruments, in a way, rely on the acceptance of the commercial community, the acceptance of the users, it is a real problem to create better accessibility, because otherwise these texts will not be taken up by the commercial community. Now, at the beginning of the last decade, the institutions thought about this a bit more in depth, and there were two possible solutions identified. The first was, as we might say, the big solution. It was a proposal of the Swiss delegation at UNCITRAL for a comprehensive global commercial code that would take these different instruments that already exist, public international law conventions, model laws, soft law instruments, principles, whatever, and stick them together into a commercial code, make sure that the different components interact properly, and then successively add to these bits and pieces. Now, this was clearly overambitious, and there was a distinct lack of political enthusiasm for such a project. So actually, it fizzled out. But what remained was the second possible solution, namely not of harmonizing or codifying more, but simply of explaining and educating better. And that could be done by a simple explanatory document, such as a legal guide that would explain these sources and their interactions. And this is exactly what was proposed by the three institutions in 2016. They all formally agreed to introduce to include the drafting of such a legal guide into their work programs, and they established a joint working group with 5 members from a number of continents. These were Lauro Gama from Brazil, Pilar Perez Vizquilla from Spain, Hiro Sono from Japan, and myself from Germany. And we were supported and guided and in a way directed by representatives of the 3 institutions, Luca Castellani from UNCITRAL, Anna Veneziano from UNIDRA, and Ning Zhao from the Hague Conference. The working group was given the task to elaborate this legal guide We worked on this for more than 3 years, had a couple of meetings where we discussed the best way to proceed. But it's important to understand that it is really a guide published by the institutions, and the text that is published does not 100% match the final draft of the expert working group. So in a way, the political process took over at a certain stage, and these are institutional documents. And if I'm speaking on the legal guide now, I do this in an entirely personal capacity, although I have to say I have no serious objections to any parts of the legal guide. I don't wish to distance myself. I actually think it is a very good document. It's just important to know it's not our document as experts, it's an institutional document. The status is that it has been approved for publication during the past few months by all 3 institutions. They all needed to go through their governing councils and governing boards to have this approval. And it is now being prepared for joint publication, which should occur in the coming month. At the moment, the English text is being translated into the 6 working languages of UNCITRAL, or the 6 official languages of UNCITRAL. Now, what is in the legal guide? There are 2 major parts. The first deals with the topic that Professor Garg will address a little bit later on. It deals with the determination of law that is applicable to international commercial contracts. This is mostly the domain of the Hague Convention, which published the Hague Principles on Choice of Law in International Commercial Contracts a few years ago. And the second part is on the substantive law of international sales contracts. And this has 4 subparts. First, it deals with the Convention on the International Sale of Goods, the CISG. Secondly, with the so-called Limitation Convention for contracts of the sale of international goods, international sale of goods. The third subsection deals with the UNIDROIT principles of international commercial contracts, and the fourth subsection deals with further texts and model contracts in the field. And obviously that is information that is available everywhere else, but what is new and specific is the focus on the interaction of these documents. So what are the overlaps, what are potential contradictions, and how can perhaps one instrument be used in order to interpret other instruments? And of course, the most neuralgic point in practice is the process of gap filling in the CISC. That is well known to people working in the field, that there have been constant proposals to fall back on the UNIDROIT principles, which are much more comprehensive, if there is a gap in the CISC. And the legal guide takes a position on this, and this position has now been endorsed by the 3 institutions. So I think that is a major step forward in ensuring that transnational commercial contract law becomes a more coherent and principled body where the interactions and the interfaces are clearer. Now, the legal status of this guide is simply that of a consultative document. It has no legal bindingness. It's not hard and binding law. It simply is a guide. But it has, of course, enormous interpretative value because it reflects the current thinking of the 3 institutions that stand behind the main instruments in the field. Now, I just have to stick to my time, so I'm drawing a conclusion here. You might actually say that by publishing this legal guide, the 3 institutions simply add to the problem that they try to remedy, because all of a sudden we have just a further text in the field that you might actually say adds to the complexity of legal sources. That is, as I said earlier on, the problem that we started with. Now, what I hope is that although we add to the quantity of texts in the field, we actually also have managed to improve the quality and to reduce the complexity by simply explaining a coherent approach. And this should make it more, or this should make the field more accessible, and should it make it easier for parties and their legal advisors to engage in international commercial contracts. Thank you very much for your attention, and obviously I look forward to answering any questions you might have later on in the discussion. Thank you.
Thank you, Professor Fogenauer, for that illuminating presentation. And it's certainly a major project. And as you have mentioned, 3 great institutions coming together, and it's also that they are not competing. It's it's an interesting statement that yes, we should look for coordination, and this is true sense of harmonization. With this note, I invite Professor Janice Dencott for her presentation on the intellectual property issues.
Great, thank you very much. I'm just going to switch to my PowerPoint and share that with you. So hopefully it will appear on your screens pretty much now. Yes, so thank you very much. I'm Associate Professor Dr. Janice Dencott from Nottingham Law School in the UK. This talk really fits within the entrepreneur section of this transnational law conference. And it's based on some work I did earlier for the American Bar Association. So let me just see if I can press down. How do I move along? Sorry. And we're going to look at fintech business models, as you would say from the business point of view, but from an IP point of view, we tend to refer to the business models as a business method. And there are some differing approaches to patentability of business methods. And that's how this topic fits within the transnational law theme. So what is fintech? Well, it's very new, really. It's only in the last decade or so that people are using these new disruptive technologies. Basically, they involve new business models, new business methods that challenge existing products and services to make them more accessible, perhaps cheaper, perhaps faster, and more inclusive as well. And it's important to realize that fintech innovations can be devised by both startups and mature financial institutions. So they do come from a wide range of sources. However, with a startup, essentially from a finance point of view, and that's one of my areas of interest, according to Francis Gurry, former Director General of WIPO, with a startup, you're basically backing an intangible asset, and the intellectual property is a vector for that collaboration. So it's quite an important aspect of creating a solid foundation for successful fintechs. And if we look at the world's top 10 mature fintech firms, you'll see actually they're not very old at all. The oldest one, and you've only really probably started to hear about this fintech in the press, is Klarna from Sweden. You can see they come from a range of countries, and that adds to the transnational complexity. Now, most fintechs don't survive. They don't survive the upheaval of change and competition, dealing with regulatory bodies, and simply getting acceptance in the market. So we want to see in businesses that grow from inventor, creator, startup to SMEs through to large private public, and because in this world we've seen, particularly in the pandemic, that we need a range of companies. Particularly the larger companies seem to have the ability to withstand these important sharp shocks. So how do we grow fintechs to maturity? Well, we have to focus on a strong portfolio of exclusive monopolistic IP rights, such as patents, trademarks, and copyright. And these can become unique core strengths for these firms. And they also benefit the shareholders of the company, the employees of the company, the customers, suppliers, communities. They have quite an impact. Now, I'm going to tell you about an interesting example of a successful American business method that was patented in the mid-90s. You'll all have heard of it. You'll probably all have used it. It's basically the Amazon one-click technology. You put in your financial details once, and then thereafter, you just have to click add to your shopping cart, buy. You don't have to re-enter all your credit card details. This was an example of a very successful method of doing business that was able to be patented in the US. Now, this patent expired a few years ago in 2017, but it helped to make Amazon the business that it is. And it's now, incredibly powerful business. And one of the reasons it's so powerful is it was also able to license this type of business method to other companies such as Apple, for example. So it was deriving passive income as well as its online shopping business. So all fintechs need an IP strategy, and that enables them to control the use of their IP rights, particularly their patent rights, because patent rights have been shown to be an important aspect of financial longevity for companies. But there are other IP rights in fintech. You've got copyright that covers the software, the computer code, visual interface features, audio, video guides, application programming, and other works. You have the trade secrets and confidential information that protect the back-end server processes. You don't have to formally register that in this country and in most other countries, but you do have to take reasonable steps to take your know-how and confidential information secret. Other important IP rights, I've mentioned patents. They are particularly important because they protect the core technological innovation. So the way the technology works, the device, the apparatus, the business method, or the process. There are also designs to protect the physical look and feel, the 3D appearance of electronic cards, transaction machines, computer interfaces, and icons. And then finally, as the company grows and brand recognition increases, the trademark becomes much more valuable, and it's important to be able to point to a registered trademark, particularly as the company grows and is seeking finance. So patenting and performance, it has a real impact because that is what IPO, initial public offering events, where the firm is going to be financed by the public, will be looked at by shareholders and investors and other institutional investors as well. And so a strong patent portfolio, IP portfolio, has been shown by previous research to be positively associated with future growth and survival in the long term. So patents are particularly important. What they do, if you're not familiar with patent and why you should patent a fintech invention, is because it provides a potential 20-year monopoly. So you can generate income from licensing this invention to other businesses as well as use it yourself. It also stops others from using your business method, your invention, without others' permission, or without your permission, sorry. It allows you to maximize the return on upfront investment. However, the quid pro quo with the government is that the invention will pass into the public domain on the expiry of that 20-year monopoly period, as we saw with Amazon's one-click business method, and then it becomes free to use, technical body of knowledge. Now, in the UK, the patent law system is devised to support the strongest inventions and give them a monopoly or a competitive advantage, because they can stop others from using their advantage, their invention. So we're going to look then at what is patentable, because of course, not everything that is an innovation is patentable. And innovations in the field of fintech are under a greater level of scrutiny at the moment from the IP community. The jurisprudence in relation to fintech innovations are constantly evolving. And basically, the courts at the moment, and this is the transnational law issue, are really struggling to establish clear delineations of what is patentable and what isn't, particularly in the field of fintech. So if you look at the legislation, basically each Patents Act in any WTO country has flexibilities under the TRIPS agreement to include exclusions from patentability, i.e. what the law will not grant a patent monopoly over. So in the UK and Europe, important exclusions from patentability include computer programs as such, mathematical models, presentation of information, and importantly, methods of doing business. Now, this was not the case in the US, and it still is not entirely the case in the US. However, the United States Supreme Court's decision in the Alice case has really starting to close the door on patentability of business methods in that country. So you can see that the courts in the US are starting to converge with the wider UK European view. However, there's not an express exclusion of a method of doing business under the US Patents Act, as far as I'm aware. So this is an example of, transnational issues for startups, for businesses, any business that's involved in the fintech space, in terms of what IP rights they can obtain in different countries in which they operate. And of course, in the digital environment, there's no borders there. However, the IP rights law system creates such borders. So the US case in Alice created a two-step eligibility test for computer-implemented inventions. And they said that if an invention is directed to a patent-ineligible abstract idea under the first step, then the second step determines whether the patent's claims, which places the public on notice of the scope of the patentee's right to exclude, recites elements that transform the abstract idea into a patentable invention, i.e. how it actually works. And so this decision and the test created in it, when applied to a patent application, determines that the mere use of commercially available computing devices and software to implement an abstract concept is ineligible for patent protection. So again, coming closer to the UK European position. However, at a transnational level, you still need to be very much in tune with the case law in the US. There's no clear exclusion. So this creates, a fair level of uncertainty, particularly at the front end of the R&D process, of the development of innovation. And the TRIPS flexibility still permit these different approaches and exclusions to the monopoly privilege. So whether or not there's a convergence of consensus has yet to be determined. But the more important issue, in my view, is the whole approach to patentability of business methods in the fintech space. So I hope this has illustrated some of the practical issues in terms of the IP surrounding this new technology. Now, just to put your mind at rest, investors are still investing, And you can see from the latest range of funding rounds in Europe last year, you know, a lot of new fintechs are still attracting funding so that they can further develop. However, going forward, we know the research says that a strong IP rights portfolio is the foundation to get businesses over that 20-year hump, whereby they're sort of more secure in doing business. So it's important to have the patents where they're available and a decision to be made as to business methods in the fintech space. So thank you very much for your attention, and do ask me any questions during the question period. Thank you.
Thank you, Janice. So that's very interesting. Well, I really appreciate your everybody is on time. I have a slightly, extended presentation, but I hope I will just be quick and try to finish within 15 minutes. And I'm sure we will also like to provide our valued participants an opportunity to ask some questions. So let me just try to share my PPT. Right. So there is. There is some. I think best way will be to. All right. Right. So the discussion, what I try to present is what are the choice of law and the choice of courts issues, and the role of the ancestral and the unit drawer principles and the instruments. So certainly, what are international contracts? A transaction will qualify to be international if elements of more than one country are involved. There is certainly a great importance of contracts in international transactions. Then what is the situation? Issue in case of cross-border transactions, the parties, that is the traders, assuming we are thinking about the business people, the traders, they will have to deal with various legal systems. There are several types of legal systems: civil law, common law, customary law, mixed law. Then how to deal with the various legal systems? Generally, the English common law tradition tends to prevail in international transactions. There are some sources. There is a discussion what is the key features of common law, civil law, how it will continue, and how the interpretation shall continue. Now the next issue, which law applies to the contract? So governing law. Then now we come to the issue of the governing law. Every contract must have a governing law, and parties may write a governing law. They may think that all right, they may not know that they have to even write something as a governing law. So if they write, it is good. If they don't, then as per the rules of private international law, the courts have to decide. A purely domestic contract is decided on the basis of respective domestic law. A choice of foreign law is generally not permitted. Example, a German company concludes commercial contracts with a Dutch company. In the event of a contractual dispute, courts must decide whether German or Dutch substantive laws apply. Now, what is the role of applicable or governing law? Starting point, assume two companies that are domiciled in different countries conclude an international sales contract. These are the typical clauses. Most of this discussion we have had in the last session as well. I will quickly skip through some of these aspects. What is the role of a governing law? It is certainly a gap filler. Legal issues arising out of a contractual relationship that are not addressed by the contract must be resolved by the governing law. Then governing law will, in the absence of contractual provisions, determine the scope of contractual obligations, the applicable remedies in case of a contract breach and their preconditions, the extent and duration of liability of the parties in case of breach. Then taking a case study, assuming one English company orders certain production machinery from the German manufacturing company D, the order submitted to D indicates the type of the equipment, the contract price, the requested delivery dates and contains also a choice of law provisions, which is written as this order and the sales contract concluded hereunder shall be governed by English law. Now, D confirms the order towards E without any further reservation. However, due to problems with the sourcing of necessary raw material, D fails to deliver the contractual goods on time. As a consequence, E terminates the contract without granting a grace period and claim damages. English law does in principle permit the termination of a sales contract in case of any, even a short delay in delivery. Contrary to Dutch or German law, the buyer is accordingly, in the absence of a contract provision stipulating otherwise, not required to set or get a grace period. A breach of contract governed by English law does, contrary to other legal systems in Europe, does not require fault on part of the party in breach. So, through this illustration, we can see the applicability of different national laws or governing law and what could be the effect. And hence, the parties should be careful what choice they are making. Similarly, there is an example of a specific performance. So, in case of specific performance, if the contract would be governed by Dutch or under civil law state, one party would be entitled to enforce a claim for specific performance. But if the sales contract is governed by English law, the party cannot claim performance by means of repair or delivery of substitute goods, given that common law does not acknowledge a right of specific performance. So, specific performance is not a right, it is discretionary. However, it is like a claim in some civil law countries. Now, what is the solution? Solution is, if the parties do not write any governing law, then the rules of private international law will be referred to, and the courts will find out which will be the best suited law. Now, to get over these issues that the courts applying rules of private international law and identifying the governing law. Now, governing law also is not that the entire contract will be governed by only one governing law. It is possible that various issues in a contract, in an international contract, assuming there is a sales, then there is a carriage, there is a shipment, there is a supply, and there are various transactions involved across 5 countries, 5 jurisdictions, assuming, then there can be 5 different issues, and it is possible that for each of those issues, a separate governing law or applicable law needs to be identified by the court. So now what is the role of these institutions, as we have just listened to Professor Wagner, the UNCITRAL, the Hague Conference, and the UNIDROIT. The role is the harmonization and unification of the private international law. There's some of these international conventions we have elaborately listened to the presentations by Mr. Luca Castellani in the inaugural session. Chief And then certainly there are certain other instruments, for example, Hague Principles on Choice of Law in International Commercial Contracts, then choice of jurisdiction issues in cross-border contracts. Now, to go into the points of the litigation points, as per the rules of private international law, generally common law classifies multi-state cases as giving rise to one or more of three different issues. First is the jurisdiction, then to what extent and whether there will be recognition and enforcement of foreign judgments, and then the choice of law. There are certain theories to identify the proper law, connecting factors. Then what is transnational commercial law? Understanding how to understand transnational commercial law. And why are we, reading these conventions and instruments? So there are several theories, there are several ways how we can classify, but basically transnational means that the subject matter reaches across national boundaries, but not necessarily involve the interaction of state and government. This is basically a private law. It's not an international law, public international law. Now, in India, we have had a few cases, some leading cases I have mentioned. I think I will just discuss maybe one case. Is an interesting case which I always discuss in my class, British India Steam versus Shanmugh Vilas Cashew Industries. What happened was that there was a clause which read as, this contract evidenced by this bill of lading shall be governed by English law and disputes determined in England or at the option of the carrier at the port of destination according to English law, to the exclusion of the jurisdiction of the courts of any other country. So, there are certain principles of interpretation how we understand the meaning of this clause. So there is exclusion jurisdiction clause. Now, this is a choice has been provided, governed by English law and disputes determined in English, so or at the option of carrier. So this means that the jurisdiction was vested in the courts of England or at the option of carrier at the port of destination according to the English law. So there are two aspects. There is a choice of law, which is English law, and there is a choice of court, which is also England or at the option of the carrier. But what happened that this shipment was to be brought into Cochin in India, and there was a short supply. And because there was a short supply, the purchaser filed a case against the seller and the shipper. The ship was detained and the case continued. Now, if this clause could be seen, it is very much evident that case could be filed at the option of carrier according to the English law. But at the time the case was filed, the carrier did not exercise or did not object to the jurisdiction of India. He contested the jurisdiction, and accordingly he was considered to be submitting to the jurisdiction of that place. So this case was tried as in accordance with the law of India, and ultimately it reached the Supreme Court. The Supreme Court held, well, because the carrier had submitted to the jurisdiction by contesting it, so the exclusive jurisdiction clause is deemed to be waived. However, the governing law or the choice of law clause is still valid, and the case needs to be determined as per the English law. If all the lower courts decided the case as per the law of India, well, that was not appropriate because the choice of law, the governing law, was already there in the case. Similarly, we have some other cases where the Indian courts, in this case, the Supreme Court applied the French law to determine an issue of there was one issue of domicile, and what was whether in the issue of takeover code, the French law would apply or the Indian law would apply. So considering the circumstances, the Supreme Court found that it would be appropriate to apply the French law to determine this issue. So these cases, we have seen that domestic courts do apply foreign law, applying the principles of private international law. Now, if we have to do away with, those rules, because these rules are not written, it is just in the precedents, and sometimes it is difficult. Parties do not know. It becomes time consuming. It is not cost effective at all, and hence, if there can be some consistent way in which these principles can be known to the parties themselves, because prominent focus of even this present symposium is entrepreneurship and also to promote cross-border trade. We also need to promote ensure that the legal costs are kept low. And how can it be done? So it's not possible, it's not feasible for the traders, the small traders, to every time seek legal advice on structuring their contracts. They don't want to get into increasing their costs. So some of these instruments do help in the consistency. So we have the Hague Principles of Choice of Law in International Commercial Contracts, and this supports some consistent way in which the choice of law can be identified in international commercial contracts rather than applying the various rules of private international law. Now, then there is another Hague Convention of Choice of Court Agreements. Now, some of these agreements, these instruments may not be very popular yet. However, there are several issues in selecting and identifying the appropriate choice of law and choice of court issues. So these instruments do support and lead towards a consistent regime where the parties themselves can read and understand and suitably modify their contracts and transactions. So in the end, I would just like to say that the way forward for India, we need dedicated programs on transnational commercial law in India. And I am really grateful, and I greatly appreciate the support provided by Professor Foganova. He was kind enough to create time from his busy schedule. He was in India. He was at NLU Delhi for 2 weeks in 2016, and we had a wonderful program on comparative contracts. So such programs are very welcome in India. So I think that would be all that I would want to say in this session. And we are now, I think, open for some questions. We still have around 10 minutes left, and I would like to provide opportunity to our participants to raise questions. All right. So do we see any questions in the chat box? Okay, there is.
So, good afternoon, sir.
Yes.
Sir, I have a question for Professor Foganova.
Yeah.
Sir, he mentioned that there were two possible solutions to the problem. One was to have a uniform code, and the other is to have a legal guide. Sir, the second solution was adopted. I have the question: why wasn't the first solution adopted to solve the problem?
Yes, thank you very much for the question. This leads us away from legal issues into high politics and the politics of harmonization of law. I think the proposal by the Swiss government was extremely ambitious, given that any piece of harmonization or unification of private law is sensitive because it takes away from the sovereignty of national governments or the sovereignty of nation states. So states are not easily giving up their sovereignty, even on the margins. And so the label Global Commercial Contract Code, I think, was simply flagging up concerns with nation states that felt that further harmonization in this area would not be necessary. As far as I understand, the biggest objections came at the time from the US government. And as is well known, the United States are not particularly keen on multilateralism, or haven't been particularly keen on multilateralism over the past 4 or 5 years. And the Justice Department and the relevant unit within the US Justice Department very firmly came down against this proposal and said, look, what we have in terms of sources of law with the CISC, with the UNIDROIT principles, that's simply enough for a functioning international trade system, so there's no need to go further. And I think that was simply it. But the way the political process unfolded would possibly be better told by Luca Castellani of UNCITRAL, who will have been much more closely involved with these discussions.
Thank you very much, sir.
Thank you, Professor Fogenauer. I think there is one or two questions from Janice. If you can read in the chat box. Please throw some light on seeking debt financing through creating security interest over the IPs.
Oh, well, it is possible to take security over intellectual property rights, registered rights. That's part of the lender's contract. You have to notify and make public the interest in the right. And so that's not really the topic of my discussion. There are better sources of information for security interests in IP. It's becoming, I mean, it's got its basis in commerce, and it has been done, but it becomes more complex if you have rights across multiple jurisdictions that all need to be verified, and the due diligence taking place, and then enforcement. If the bank then, if the institution, the finance borrower defaults, the institution has to take over those intellectual property rights and exercise them or find a buyer for them. And that becomes a little more complex than an average transaction. That's not to say there aren't other transactions that banks very competently navigate. However, they're going to have to become much more IP aware. And one of the reasons why they're going to become more IP aware is, of course, they are going to own their own IP rights portfolio in the fintech that they either create or license. So whether they like to or not, they're going to become more IP proficient. And it may be that they actually start to drive more interest in how these IP rights are shaped as IP rights owner, full IP rights owner lobby groups, particularly in the US. However, if, for example, one country permits patentability of a business method and another doesn't, it creates a very interesting landscape for innovation across different member states of the WTO, for example, and a field. It can, I think, be very disruptive in an unexpected way. So I'm not sure if that's answered your question, but taking security over IP rights is certainly possible. However, currently it's not as common. And I know in the UK, they're currently also looking at reforming our secured transactions law, and the IP rights issues arising as part of that secured transactions reform project.
Thank you. Thank you, Professor Janice. I think, well, they've asked PPTs. Well, PPT, I think, is already saved in the system, and I don't think we will have any issues to share the PPTs. But before, I think, concluding the session, I would like to request Professor Wagner to provide his final comments as the chair of the session.
Yes, well, thank you very much. That's been extremely illuminating, not least because I'm certainly not an expert in fintech, so I found this extremely interesting. And in a way, the area of law that I cover today is perhaps a little bit more traditional and less dynamic and less fast-moving, so this was actually a fascinating insight. And also thank you very much to Professor Garg on the basics and fundamentals of conflict of laws issues. It was very interesting to see the Indian case law, with which I'm obviously not familiar, although this is, of course, an issue that comes up in all transnational commercial contracts. But I think it was a wonderful example to show how, although we're talking about transnational commercial law, ultimately it's normally national courts that make these decisions and then create national precedents. And so it will be important for us in Europe to know, for example, what the Indian position is on these issues, as it is important in India to know what the European positions are on these issues. So I actually think this was a very good session to exemplify the topic of the conference, the role of UNCITRAL and other organizations in harmonizing international law. And perhaps we should add the role of commercial practice and commercial usage, because I think this is an area of law where it's pretty clear that the law always lags behind the commercial activities, and that's how it should be. Commercial operators should be nimble. They should be pushing the boundaries of the law in order to create merchandise, products and services, and thus the law then needs to catch up and create a framework and maintain a framework within these operators can move for the collective good. And I think the financial sector is a very good example here, because we've seen before how the collective good can be harmed if there's no regulation at all. At the same time, the financial sector will only prosper if it can move with the markets and in sync with commercial interests. So I think that's been a very illuminating session, and I'm extremely grateful to all the speakers, to our to the lady who introduced us, and to the entire background or back office team that created the stable video link. And I have to say, I've been spending so much time in horrible video sessions over the past few months that I've really come to appreciate it if everything runs so smoothly. So also perhaps a silent round of applause to those who've made this all possible. Thank you very much to everyone, and I think I can now conclude the session. Thank you.
Thank you. Thank you, Professor Wagner. Thank you, Janice. Thank you for joining in. We'll
Thank you, everyone. Lovely to meet you all.
Yeah, sure. Thanks. Bye-bye. Take care.
Bye-bye.